The deadline expired Monday at 5 p.m. Eastern Time. As of this morning, the New York Attorney General has active seizure authority over Donald Trump's properties. Before you dismiss this as another threat that won't materialize, understand what legally changed in the last 48 hours. I've enforced financial judgments for 3 decades as a federal prosecutor. I've seized assets from corrupt officials, fraudsters, and defendants who thought they were above the law. Let me tell you what happens when someone refuses to pay a court-ordered judgment. You've heard speculation before. Talking heads saying they're coming for his properties. This is different. The legal mechanism just shifted. Trump had 30 days from the judgment to either pay $464 million or post an appeal bond guaranteeing that amount. He did neither. The deadline passed. The Attorney General now has court-authorized power to begin asset seizure, not theoretical power, active enforcement authority. This isn't just another witness or another indictment. This is property law, contract law, the kind of law that protects every homeowner, every business owner, every person who's ever been owed money by someone who refused to pay. I'm going to walk you through the specific court orders that explain exactly what authorities can seize, when they can seize it, and what Trump's remaining options are now that the deadline is passed. You've heard the term seizure authority. Here's what it actually means under New York law. There are 3 stages to judgment enforcement. Stage 1, judgment entered. That happened in February when Judge Engoron ruled Trump committed fraud and ordered him to pay $464 million plus interest. Stage 2, appeal bond deadline. Defendants get 30 days to either pay the judgment or post a bond guaranteeing payment if they lose on appeal. That deadline was Monday. Trump posted nothing. Stage 3 just activated. Seizure authority. Now here's what seizure authority actually authorizes. It's not sheriffs showing up tomorrow with padlocks. It's legal power to file liens against properties, freeze bank accounts and investment accounts, and force sales of assets through court-supervised auctions. Think of it this way. The court just gave the Attorney General a legal toolkit. She can now file paperwork that makes it impossible for Trump to sell, refinance, or transfer any New York property without satisfying the judgment first. Some people think Trump can delay this indefinitely by appealing. Let me be clear about what appeal without bond means. He can still file an appeal. Courts will still hear his arguments. But the appeal does not stop enforcement. That's the whole point of requiring an appeal bond. If you want to pause enforcement while you appeal, you have to guarantee you'll pay if you lose. Trump didn't post that guarantee. So enforcement proceeds while appeals happen. The judgment is $464 million. Interest accrues at roughly $87,000 per day. That's based on New York's statutory interest rate for judgments. Every day Trump doesn't pay, another $87,000 gets added. Do the math. That's $2.6 million per month. This is the 3rd major financial judgment against Trump. E. Jean Carroll won $83 million, then another $5 million. Now this fraud judgment. That's not coincidence. That's pattern of non-payment. Now that you understand the legal authority that just activated, let me show you which specific properties are in immediate jeopardy. Let me walk you through the asset inventory, because not all properties are equally vulnerable. First, Trump Tower on 5th Avenue in Manhattan. This is the most recognizable Trump property. He owns the penthouse where he lived. He also owns significant commercial office space in that building. Here's the property deed filed in New York County, public record. Here's the assessed value based on court-ordered independent appraisal, approximately $300 million. Not the $1 billion Trump claims. $300 million based on actual market analysis. Trump Tower is vulnerable for 3 reasons. It's located in New York, so state jurisdiction is clear. The title is relatively clean compared to other properties. And it's partially commercial real estate, which is easier to seize than primary residences. Second property, 40 Wall Street. This is a 70-story office building in Lower Manhattan. Trump has a ground lease, meaning he doesn't own the land but has rights to the building. Court-ordered assessment, approximately $130 million in lease value. This property is vulnerable because it generates rental income. Authorities can place liens that intercept that income stream. Third, Seven Springs Estate in Westchester County, New York. This is a 200-acre property north of the city. Assessed value, approximately $25 million. This property was actually central to the fraud case. Prosecutors allege Trump massively inflated its value on financial statements. Now it's subject to seizure. Fourth, Trump National Golf Club properties in New York, Westchester and the Bronx locations. Combined assessed value, approximately $30 million. Here's what makes these assets vulnerable. They're all in New York. The Attorney General doesn't need to go to courts in other states. She files paperwork in New York County and Westchester County. Done. They all have clear public records of ownership. And Trump claims these properties are worth billions. Independent assessments show hundreds of millions. That gap matters. It shows inflated valuations, which was the fraud the court found. Now contrast that with what Trump says. He claims his properties are worth far more. He says this judgment is unfair because his assets exceed the judgment amount. But the court already found he systematically inflated property values. That was the fraud. So when he claims Trump Tower is worth $1 billion, and independent assessment says $300 million, the court believes the assessment. That's not opinion, that's court-ordered evidence. I know some of you are wondering, can he actually lose Trump Tower? Let me address that directly with how commercial property seizures work in New York. Fair question. Does seizure authority mean sheriffs arrive tomorrow with padlocks and change the locks? Here's the actual enforcement sequence. Step 1. File judgment liens. The Attorney General can file liens against every property I just listed. That can happen immediately, this week. Once liens are filed, Trump cannot sell or refinance those properties without paying the judgment first. The lien attaches to the property. It travels with the title. Step 2. Freeze bank accounts and investment accounts. This requires filing a motion with the court, but it's a straightforward motion when you have an unpaid judgment. Typically takes 1 to 2 weeks. Once accounts are frozen, Trump cannot access those funds without court permission. The frozen funds go towards satisfying the judgment. Step 3. Force property sales through court-supervised auctions. This is the longest process, typically 3 to 6 months. The court appoints a receiver who manages the sale. The property gets appraised independently. It goes to auction. Proceeds go to satisfy the judgment. Now here's what people misunderstand. This doesn't mean Trump keeps his assets while appeals drag on for years. The liens prevent him from moving assets. The frozen accounts prevent him from accessing liquid cash. He's effectively locked in place while enforcement proceeds. In enforcement cases, attorneys general typically start with the easiest assets first. Bank accounts, investment accounts, publicly traded securities. These are liquid. They can be seized and liquidated quickly. Then comes real estate, which takes longer but generates the larger amounts needed to satisfy a $464 million judgment. Every day Trump doesn't pay, $87,000 in interest accrues. That's not symbolic. That's real money added to what he owes. $2.6 million per month. If this drags on for a year while authorities work through the property seizure process, that's another $31 million. The judgment grows while enforcement proceeds. So can Trump stop this process? Let me show you what his legal options actually are now that the deadline passed. Here's what Trump's remaining legal options are, and why none of them work. Option 1. Appeal without bond. He can file an appeal arguing the judgment was wrong. But as I explained, appeal without bond doesn't stop enforcement. The Attorney General proceeds with liens, account freezes, and property seizures while the appeal gets heard. Appeals take months, sometimes years. Enforcement happens now. Option 2. Declare bankruptcy. Some defendants try this. Personal bankruptcy doesn't discharge fraud judgments. That's settled law. You can't commit fraud, get sued, lose, then wipe out the judgment through bankruptcy. Fraud judgments survive bankruptcy. Corporate bankruptcy doesn't help either. These properties are held in various corporate entities, but Trump personally guaranteed many of the loans and obligations. Piercing the corporate veil in fraud cases is standard procedure. Option 3. Try to move assets or hide them. Too late. The judgment created a lien the moment it was entered. Any attempt to transfer property or move assets now would be fraudulent conveyance. That's a separate crime. I've prosecuted cases where defendants tried to hide assets after judgment. It never works. It just adds criminal charges on top of civil liability. Option 4. Negotiate a payment plan. Trump's lawyers tried this. They offered to pay a smaller amount over time. The Attorney General rejected it. She doesn't have to negotiate. She has a court judgment. She has enforcement authority. Defendants don't get to dictate terms after they've lost in court and missed the appeal bond deadline. His lawyers will argue financial hardship. They'll say forcing asset sales will cause irreparable harm. But the court already found Trump has accessible assets worth hundreds of millions of dollars. The fraud case proved he has significant wealth. He just doesn't want to pay.